in a number of times from our audience. I don't know who wants to take the lead on this, maybe Mike, maybe Steve, but the question from our audience was, how can corporations possibly use 220 requests to their advantage, and is there an advantage to a 220 request?
This is Mike, and I think Steve will probably jump in on this as well. And I think we both kind of touched on this. The way you take advantage of it is you essentially can cut them off at the pass. So if they're challenging you on a care mark, take care mark as your situation where you have an oversight obligation. This is an opportunity to have your minutes, not, obviously not making things up, but to record what you're doing, control the, put in your minutes the controls that are in place for these material risks. Put in that the board was looking at these risks, either directly or indirectly through a committee. You can state these things in a summary fashion, but what the courts will say is, if you can point to that in your minutes and show that you are in fact looking at the risk, which under Caremark is really what the board needs to be doing, that will cut off, not only will take care of the 220 demand where you can produce it voluntarily in that context, it'll cut them off at the pass for purposes of going forward with derivative. And I'll hush now and let Steve jump in.
Yeah, I agree with that, especially with the incorporation by reference principle that being used in most cases. Under Delaware law, you have to show, like, for example, that the company utterly failed to have a reporting process in place to ferret out wrongdoing, so to speak. And the 220 process gives the company the opportunity to put in all the documents. That's why I think it's important to make sure the production is fulsome, showing that what the reporting process was, so that you have an audit committee, you have a compliance officer, you have a hotline for employees to make complaints. So if you can show that these processes are in place, which goes to a long way. For example, again, you have to show another failure. So you only have to try to have a reporting system in place, and you can provide the documents. And the same thing with respect to red flags. You can show the board was made aware of this and it took X, Y, and Z action. So yeah, the 220 action can be very beneficial to the company in sort of eliminating or disproving Caremark claims.